You're also on the advisory board of the Global Judicial Integrity Network, and you are involved. Are you involved in a particular subject area? Because there are about 21 different subject areas of that organization.
Right. Yes, the Global Judicial Integrity Network, which is part of the United Nations Office on Drugs and Crime, is funded by the Qatar government. And the whole idea was to promote ethical behavior among judiciaries the world over. There are 12 of us on the advisory board from countries all over the world. I was very humbled to be selected on that. I think my work with CAJO and with judicial education, I think would have been responsible in the main for being selected to be on that advisory body. But what we've done, we've created a swath of tools for judges to assist them in dealing with gender sensitivity, to assist them in enhancing ethical behavior, to assist them in making their courts more effective, more responsive to what we call social context issues. And we've done quite a lot of work training trainers throughout the world.
So this is a global project. It has global impact. It's not confined to the Caribbean.
Yeah, no, not at all. This is a global project.
And as much as you are humbled, we are extremely proud of you for actually being appointed to that board. And thank you for your service. I want to congratulate you. There's an article in the Daily Nation, an editorial in the Daily Nation that heaps praises on the Caribbean Court of Justice. And it actually compares the Caribbean Court of Justice in different ways with the US Supreme Court. And they were talking about the fact that in the Caribbean, one of the problems that we were complaining about is the impact of government on judges and judges' decisions. And that whereas there's no proof of that in the Caribbean, it can certainly happen in the United States, where they are appointed by the United States government. How are the judges in the Caribbean Court of Justice are not appointed by the governments, but the president has to be approved by all of the Caribbean prime ministers. How does that impact the argument that the president can be subject to influence?
Right. I think that's a very remote possibility for a number of reasons. The first one is that fundamentally, the president is selected in pretty much the same way as the other judges, and that is the Judicial and Legal Services Commission, which is a body that comprises a broad range of persons in civil society, from bar associations, law schools. There is a sitting Chief Justice on it. There are two persons from the Public Services Commission on it on a rotating basis throughout the Caribbean. So it's a fairly diverse body. If there's a vacancy, we advertise the vacancy, whether for president or for judge. And there are set criteria which have been established, and those are advertised as well. The criteria are made available. And persons who wish to apply, they apply. We go through their CVs. You have to submit with the application a lot of material to demonstrate that you can or have met the criteria. And a shortlist is created, and the shortlisted persons are interviewed. That is the same for judges and for the president. In the case of the president, and then a selection is made. In the case of the president, a selection is made, one person, and that selectee, the name of that person, then goes before the heads of government of CARICOM. And it's not a unanimous vote, it's by a 3/4 majority. They must agree on that person. If 3/4 can't agree, then it isn't that they say, okay, we don't like Adrian, we like Harry, and they pick Harry. They say, no, they tell the commission that, I'm sorry, we have not been able to agree on Adrian. We would like you to select another nominee. So that the person who is appointed must first have been selected by the commission. And so that minimizes any possibility that there is any improper governmental influence on the selection process. I would be very surprised if a selectee is ever not approved by a 3/4 majority. After all, they've gone through a rigorous process. And our system has a built-in process for almost ruling out any improper prime ministerial intervention. And it is this: the CCJ is not only a court that takes appeals from particular countries, it is also a court that resolves disputes between and among Caribbean states, so that each state has an interest in ensuring that the judges and the president of the court are of impeccable character, are persons who would not easily be influenced improperly, because that judge, those judges, that president will be presiding over disputes between your state and another state in CARICOM. So the prime ministers cannot collude among themselves to put in place judges or a president that will do their bidding, because they have adversarial interests between and among themselves in relation to how this judge or president will be ruling.
And with that being said, what would you think are the stumbling blocks then to persons who go to referendum and still vote against having the Caribbean Court of Justice in both of its jurisdictions?
That's a long issue, story. You know, there are some decisions. This might sound anti-democratic, but I don't care. There are some decisions, national decisions, that must be made by leaders. The 5 countries that to date have joined the CCJ, none has gone through a referendum process. It's speculation as to whether, if they had gone through that process, the people of the country would have agreed. But those were decisions taken by the leadership, by the parliaments of Guyana, Barbados, Belize, Dominica, and recently St. Lucia, in the interest of the people of their respective countries. And I think that that is the approach that should be taken. We never had a referendum to determine whether slavery should be abolished. We never had a referendum to determine whether to have adult suffrage. We never had a referendum to determine even whether we should be independent, whether we should be an associated state. Those were decisions made mostly by colonial governments, but those are decisions that were made at a different level. Whether or not you should have a final court representing you in place of the Judicial Committee of the Privy Council is a decision which, in my view, is of the same ilk. Because what has happened in the two countries, Grenada and Antigua and Barbuda, where they've had no choice but to go to a referendum because of their constitutional makeup, is that the referendum has become infused with all manner of things that have little to do with the CCJ. An opposition party might take the view that, well, this is a good time for us to demand that the government do X, Y, Z, which the government had not wanted to do, or else we wouldn't support. Now, that's a kind of blackmail that the governments naturally will not go for. Sometimes the quid pro quo is set at such an unreasonably high level in any event that no government will want to give in to that. And not surprisingly, the referenda have failed because one party has gone out and asked its supporters to vote against it. We have instances where some opposition parties, they tell you straight, we don't have a problem with you, we don't have a problem with the CCJ, but we have a problem with the Prime Minister. I don't understand the logic of that. You either, in principle, consider the CCJ to be a worthy replacement of the Privy Council, or you don't. But to tell me that it is a worthy replacement, but you have a difficulty with agreeing with the government on that issue, or you don't want the government to get the kudos for making that move. I think it's a very unfortunate kind of approach. I don't think it's...
Certainly the people are being used as pawns in a political game.
Yeah.
So we know that people are being used as pawns, and we understand that there is no political interference. In some cases, there was never even a referendum for the decision to be taken, for the court to be adopted. What would you say if you were talking to a man on the street who perhaps had previously, in a referendum, voted, and then among the casualties was the fact that the CCJ was not adopted? What would you say are the most compelling reasons for the adoption of the CCJ?
I think the most compelling reason is that adopting the CCJ affords people of ordinary means access to justice at the highest level. Many of the cases that we have had, and cases that have made a profound influence on the law, were cases that were filed by ordinary people who would never have been able to afford going to the Privy Council to argue the particular cases that they brought before us. The cost, the financial cost of going to the CCJ is a fraction of what it costs to go to the Privy Council. So that is the most immediate argument that I think would appeal to the ordinary woman and man on the street. But there are more, there are even more ideological arguments that may not immediately appeal to someone, an ordinary person on the streets. And that is that, judging is something which requires the judges to see from near and judge from far. And it holds good for every kind of contest that you have a judge. If you're judging a beauty show, a steel band competition, musical rendition, the judges get the best seat in the house because they have to have the best view. They have to be near to the action. It's no different with a judge in court. A judge has to be familiar with the nuances, with the life, with the history, with all of the social influences that bear on the dispute in order to be able to give the best possible judgment. You can't stay across the Atlantic and give a more effective judgment about a very serious constitutional issue as a judge who is from the region, or at least, if not from the country itself, from the region, who knows the mores and the ways and the habits, the inclinations, the aspirations of our people, and you know, who is therefore able to factor all of those things in making the decision. To my mind, there is what I call a judicial deficit, where you have a judge who makes decisions for a polity, for a country, and who does not experience for themselves the consequences of the decisions they make. Because you could do anything, it doesn't affect you. You don't live that decision. But that is what has been happening for us with hundreds of years, so far as our final appellate decisions are concerned. You have persons who make decisions, and then they don't look back because they're not from there, you know. And to my mind, these are some of the reasons why it is important to find a good alternative to sending your decisions to London. The question is the CCJ a good alternative? In 2005, I would have been sympathetic to the notion that, well, we don't know, because it's untested, it's untried. In 2023, after 18 years, I don't think that that argument can pass muster. The CCJ, and I'm biased, I'm the president, but I think that it is fair to say that the CCJ has demonstrated that it is a quality court, that it renders decisions that are as well reasoned as any other apex court, and that can easily be tested. Decisions are there, one can read them, and one can make an assessment. So to my mind, there is no good reason why any of these countries in the Caribbean should be continuing to send their appeals to a court that is cited in London by people who are English or Scottish, who have no real interest in the Caribbean, who do not live in the Caribbean, and who, as I said, they really, we don't know if they care because they don't experience the consequences of the decisions.
The court, I'm coming back to an issue that you raised about the death penalty, where two judges to one decided that the death penalty does not necessarily have to be the punishment for murder, the automatic. The court had initially been labeled by an international media outlet as a hanging court. Now, that judgment and the Boyce and Joseph case showed that that is not necessarily how the court feels. But does the court actually have a position, or is it that you just examine each case on its merit?
Right. The latter. A court, each individual might have her or his own philosophical views about something as serious as whether the state should execute someone, one of its citizens. I have my own philosophical views on that. But my concern as a judge is to look at the Constitution and to determine whether a law that is passed by the Parliament is in keeping with what is in the Constitution. We have a construct where each country has a written constitution, and the constitution frames all social, political, even economic life. Every law that is made by Parliament has to be consistent with the Constitution. And if it isn't, then it falls to the courts to say that it isn't and to disable that law or to modify it so as to bring it into consistency with the Constitution. Irrespective of my own philosophical views or those philosophical views of my colleagues on the bench, that is the exercise we have to carry out. And of course, you have unconscious bias, where you allow, even without you knowing it, your philosophical views to color your interpretation of the Constitution. And that's why it's important to have a diverse bench, a bench that is comprised of persons of different sexes, persons comprised of persons of different countries, different life experiences, and so on, so that there's the hope that the unconscious biases even out themselves, one way or the other. But each person has to make a supreme effort to assess in an impartial manner whether a law or a government act, some action by the government, is consistent with the Constitution. Yeah.
Justice Saunders, you said that, well, we understand now that certainly the Caribbean Court of Justice is relevant to the people who it serves or who it is meant to serve. Is Caribbean law and the Caribbean justice system relevant to the times that we are in now?
Well, that's a continuing project. We inherited what you call Caribbean law, but it's Caribbean law, from the British. If we had been colonized by France, we would have inherited the Napoleonic Code. We instead inherited English common law, and since independence, we make our own laws through the Parliament. And as I said, those laws have to be consistent with the Constitution. The common law that we inherited was, for the most part, laid down not to suit so much our interests, because we were colonies. They were laid down to suit the interests of the colonizer. And incidentally, they sometimes suited us. The point I'm making is that judges, courts need to interrogate our law. And not just the common law, because the laws passed by our parliaments too needs to be interrogated to ensure, in the case of the laws passed by the Parliament, that those laws are consistent with the Constitution. In the case of the common law, the laws that we inherited, that those laws are really in sync with our needs and our aspirations. We did some cases from Guyana, for example, a case called McEwan, where there was this 1893, I think, law that was passed by the colonial parliament in Guyana that said it is an offense for a male to be dressed in female attire or for a female to be dressed in male attire for an improper purpose. Well, all of us on the bench thought that that law was too vague because you don't know what's a proper purpose and what is an improper purpose. Not to mention even that these days unisex clothing is regarded in some quarters as a fashion trend. But the point of it is, why was that law passed? That law was part and parcel of a package of laws that was passed in the years after independence, after the abolition of slavery, and just when they started to import indentured workers from Asia. Those laws were passed to control people, to put them back onto the plantations, to exercise some kind of dominion over their thoughts, their expression, their freedoms. It's important that we find this out, that we interrogate these laws to see why they were passed. Because when we do, and we discover that the motive in passing this law had little to do with promoting the self-expression, the freedom, the liberty of the Guyanese people, but instead, these laws were passed in order to assist the colonizer to better control Guyanese people. It is when you do that, you recognize the impropriety of this law continuing to govern the lives of the people of Guyana. And so judges, to me, have a special responsibility, and lawyers too, because lawyers have to point it out and cite it to the judge, to interrogate our laws in order to, and not just assume what is the law. So, but to interrogate the laws to see the extent to which, if at all, these laws are consistent with what is in our best interest. And if it is possible, if the law is unconstitutional, to disable it. If it is not unconstitutional, to point out to the parliament that something needs to be done about this law.
So in addition to, as you say, examining the law to see what was the original intent behind it, what else would you like to see happen to ensure that the laws are more appropriate for Caribbean people and the times that we live in?
Well, I think that each country should have a law reform, what they call a law reform commission, a group of experts, not just from government, but from the private sector, that, because you need to keep examining the law to ensure that it is in the best interest of the country. Society is dynamic, and law must reflect the dynamism in society. So that invariably, a law that was established in the 19th century, if it's still on the books, is hardly likely to be serving the interests of people in the 21st century. But there are many laws that are still on the books that have been passed in the 19th century. Unfortunately, it's a case very often where the government doesn't have there are more pressing priorities, it is thought, than to resource a law commission that will do that exercise. But this is important, and very often, or from time to time, you come upon instances like that one in Guyana. We had another case in Guyana, same thing, where another law in the 1890s again allowed the person who now exercises the functions of the DPP, in those days it was the Attorney General, allows the Attorney General to direct a magistrate to commit someone for trial, even if the magistrate thought that the person was not, there was no evidence linking the person to the crime. And that issue came up before us, and we said, no, you have to disable that law. And Parliament needs to revisit it, because you can't have a DPP appearing before the magistrate ostensibly as a litigant, as a party, and also being able to direct the magistrate what to do and to supersede the magistrate's own judicial decision making. But what is astonishing is that these kinds of laws are still on the statute books.